You have the right to remain silent.
Silencio.
Anything you say can or will
Lo
be
que
used
usted diga,
against you.
hay poder ser usado en
Can
su
we also
contra.
do the other one as well? Might as well.
It's a BWI.
It's okay.
Sure, okay. Velasquez. And Judge, that one's on page 17.
Got it.
Buenos días, señor Jesús, intérprete. Por favor, conteste todo a voz alta.
Both of you are charged with criminal cases. We are going to do probable cause on each of your
Cada uno
cases.
de sus casos.
After that, we will determine whether we will do bond conditions. Each of you have the right
Cada
to
uno de
remain
ustedes tiene el
silent.
derecho a tener silencio.
You have the right to have an attorney
Tiene el derecho a
present.
un abogado
If
presente.
you cannot afford one,
Un abogado, uno se le nombrará.
let's start with Ms. Herrera.
Yes, Judge.
Empezando con ella.
On March 1st,
El 1 de marzo
2025,
del
the officer
2025,
made
los
contact
hicieron contacto
with the suspect and
con la-
complainant inside a JCPenney's loss
con
prevention office.
JCPenney.
The loss prevention team provided all information needed to place the suspect in custody.
Y en la
The
sospechosa tenía la persona bajo
complainant and loss
custodia.
prevention team
El equipo de
advised
prevención
they observed the
dijeron que
suspect
observaron a la
on CCTV footage,
sospechosa
select
en
multiple
la
items
cinta,
on the store
poniendo
floor
múltiples
before
artículos
entering the dressing room
antes
with
de
a
entrar al
backpack
salón
she
de
brought in. The suspect
cambio,
then exited the dressing room
mochila que
without any
tenía.
items.
Entonces
The
salió
dressing rooms
sin
were swept
artículos.
by loss prevention before
Miraron
and
el
after, occupied by the
salón
suspect,
de-
and the suspect exited all points of
ella salió de
sale without
todos los
attempting to
puntos-
purchase.
todos los puntos
The
de
total
venta sin
amount was
tratar de pagar.
$203.
La cantidad total fueron $203.
Going, did they find something else? Because it looks like she picked up a second case as well.
Furthermore,
Dice,
when
además,
they took her to Humboldt Jail,
además, cuando
during
llevaron
a
a
search
la
at the
cárcel,
jail,
ambos
the staff found folded dollar bills in the defendant's jacket
encontraron
pocket,
dólares
which contained a
en el
white powdery
bolsillo
substance identified
de
as
la acusada que
cocaine
tenía.
weighing
Se
0.16
identificó como
grams.
cocaína, que pesaba punto.
Ms. Herrera, I'm going to find that there's sufficient probable cause to go forward with the case.
Para seguir haciendo
I'm ordering you as a
paso.
condition of your bond not to consume
Yes.
alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs,
Yo
then I will revoke your bond, put you in jail.
revocar tu fianza, lo pongo en la cárcel.
You're also ordered not to go back to any JCPenney as
Regrese a
well.
ningún JCPenney's.
Okay, so let's start on Mr. Velasquez now.
Velasquez. Yeah,
Mira
yeah.
la-
Mr. Velasquez, you are charged with driving while intoxicated.
Ebrio.
You are facing up to 6 months in jail and or a $2,000 fine.
Yes, Judge. On March 1st, 2025, the officer responded to a loud music complaint from a vehicle at Main Street, South Houston, in Harris County, Texas. The officer made contact with the defendant, who displayed slurred speech, a strong odor of an alcoholic beverage, and very poor balance. Standard field sobriety tests were administered, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. The defendant consented to breath with results of 0.142 and 0.139.
Is he listening to music while being Hispanic? Really?
So that was the basis of the stop, was the loud music complaint, and that's when they approached the vehicle.
You never even said that he was driving.
And that's all there is, Your Honor.
Was he driving?
He was in the vehicle, but we
So?
don't have, and Your Honor, we understand, yes, there's, Nothing in the
says
DMs.
he was driving either.
we don't have that information, Judge, so we understand if you find a PC.
Mr. Velasquez, I'm going to find that there's no probable cause to go forward with your case. You know, you need to be very careful, especially if you're not in this country with permission. There are a lot of people here when they go to jail and they don't have permission to be in this country. Immigration sweeps it on a daily basis, every 4 to 6 hours, you know? And if they find you in custody and you're not here with permission, they'll put a detainer on you and you'll be stuck in there for who knows how long. I don't know what your status is, but be very careful how you act. You understand? All right, please take a seat for me, sir. I've placed conditions on your bond, ma'am. If I find that you violate these conditions, I will put you in jail. I will protect my community at all costs. It doesn't matter to me what's going on. Do you understand? So Do you have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer,
Le
ma'am?
nombre un abogado de planta. Por appointed.
So, if you're going, we'll give you an application. I'll have you fill it out and then I'll take a look at it. For now, I'll also have you sign a receipt with
También tiene que-
Ramona. You will get with Fleischer for your bond conditions, and then we'll have you take a seat in the jury box, ma'am.
Eso para las condiciones de fianza, siéntese.
She's being monitored. Okay. Mr. Pons was waiting, but
No, not.
Mr. Pons, he's been so
Waiting patiently to.
patiently.
I was gonna ask for a PR bond for Miss Rice. She's got a parole hold. After this, I'm gonna talk to her about the next step.
But I mean, are they going to send her to parole then? If we give her a PR bond?
I'm sorry?
Will they send her to?
Yeah. But then if you give her a PR bond, we can have the next conversation about taking care of the case today.
I don't know. What do you,
Or send her any bond. Sorry.
Deputy Miranda, would you mind bringing Miss Rice out? Yeah.
It's gonna, okay.
I don't know anything about anything. So let me see.
She has a parole hold for failure to report. She's got a false ID while having a parole hold. So if you give her a PR bond, she's still gonna be there. Parole's gonna come and talk to her.
Yeah.
I have all the discovery in the case, so my plan's to talk to her about that after I talk to her about her bond rights.
Guys, what say you? Talk about Miss Rice.
Yes, Judge. And I
Sure.
have spoke to defense. We have offered a time served in this case.
What's your position on the PR bond?
On the PR, I mean, we would like to get the case resolved before she's sent over,
You're okay with the PR bond?
but
She would still be in custody.
She's not, I mean, she's got a parole hold, so it's, but
Different.
my only issue is, do they send them to?
If there is a parole, I don't think it matters what bond.
Right.
They're not gonna pick her up or take
I
her.
doubt it.
I
They're
don't.
gonna wait and.
Wait till this is done. Okay.
They want to see this resolved, yeah.
Yeah, okay.
But,
They're gonna
I
wait.
want to be kosher. Make sure I get
Get you
the
going.
bond set first.
Tell them not to worry about it. We're good. Okay.
Thank you, Judge.
I'll get her. You got it.
Thank you. I'll be right back.
Judge, yes, only your vote.
Yeah. Mr. Beadle, did you want to talk about something?
Yeah, Judge, I'm in the rain. That's why I'm playing PC and then it. I'm teaching this young man how to grow a beard.
I
I teach everybody.
need help too. I can't grow a mustache. It looks like, You ready?
I'm absolutely.
Please.
Yes,
We're talking.
Mr. Madrono, Judge, Abel Madrono.
Yeah. Good morning, Mr. Madrono. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On March 1st, 2025, the officer observed a white Honda CRV involved in a minor accident. The defendant was traveling southbound on Dennis Street when he struck a 2016 gray Lexus. The defendant admitted to consuming alcohol recently and standard field sobriety tests were administered. HGN 4 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant refused breath.
Hey, he admitted to consuming alcohol recently. So what?
And Your Honor, there are no other indications of intoxication listed in the DIMS.
No slurred speech, no bloodshot eyes, no,
We don't have that.
not even a note of alcohol.
No, Your Honor. None
Your
of that.
Honor, what we do have is that there was an accident and another officer told him that he thought that the defendant was intoxicated. We don't know what that other officer observed,
Right.
based on the DIMS
Yeah.
facts.
All right. I'm going to find no problem cause. Mr. Madrono,
I'll explain.
be careful, man. I mean, look, every single day, someone dies from an alcohol-related collision in our county. Every single day. $50, $40, Uber, anywhere you want to go. Don't matter where you want to go. You know what I mean? All right. Good luck. Please.
Thank you, Judge.
Thanks.
I'll be able to, I'll tell you what it is. Whatever stats, chips, large stats.
Judge, ready for this? the rest of them.
Yeah. Oh, what? No. Hold on. Ms. Strong, I've got two more lawyers here.
She's here on.
Good morning, Judge. I have
Hi.
Jose Guerrero. He's there. He's the one that you sent for a drug test yesterday.
Okay.
Yes, he's here.
Mr. Guerrero?
Judge was negative.
Oh, negative. Okay.
Yes.
So we'll just give you a normal reset then. So, Mr. Guerrero,
Thank you.
just take a seat. You're good. We'll just give you a normal reset then. Okay?
Thank you, Judge.
Yes, for sure. You have anyone else?
I have Guadalupe Guerrero on docket. He was on docket yesterday, so I'm not sure why he popped up today.
He signed conditions and everything with me, Judge.
I don't,
It's because we raised, I think, the dollar on the original sold.
that's why. Whenever we revoke someone's bond and then, raise it even $1, whatever, they always auto-populate the next day. So that's
Okay.
why. But we can just give you the date, whatever you want, regardless. So
Okay.
you want to just chat with Ramona here? She's in the court, in the virtual court, just whatever date you want, you're good.
I'll chat with her. Thank you, Judge.
Thanks. Colin.
Judge, what was the amount on the PR bond? Just 100?
Just whatever it is now, it doesn't matter.
Yes, Judge.
There's a bond, is there a bond set? Or
Judge,
Can you hear me?
then leave it there. Hey, Colin. So is there a problem with the PR bond?
Can you hear me, Judge?
I can hear you.
I can't hear you. I don't know what's going on.
Can you not hear me?
No. I'll jump out and come back in.
Log out. Frank.
Hey, Jeff.
Hey.
Yeah, Rich. I like your seat.
What's going on, man?
Morning. I came early.
Son?
Yeah, my son.
Nice. That's right. Good job.
Thank you.
You've already been here before, right?
Yes, Your Honor.
I'm so sorry. What's going on?
Judge, I came earlier this week on a John Malith Bojorquez, and
Is it on docket today?
no, it's not on docket, but you told me to bring her in. You said it
Did
was.
she get an immigration bond or something?
No. She just she had a pretrial bond. She
Did you have a violation or something?
No, she just didn't show up that day, so they issued a
Okay, what's your cause number?
cause number is 25309.
I remember now.
Yeah,
Right. Okay, 09.
52.
So this was she never appeared for her arraignment. We issued a warrant, so now she's here. Do you mind bringing her up?
Yes. That lady?
Do you need a translator?
No, she speaks English. She's a U.S. citizen.
It's 2530953.
2530952.
Ahem. Ahem.
Great to see you, Jeff.
Bruce, can I get that call?
Yeah, it's 2530952. You are Ms. Borquez.
Yes.
Ma'am, you're charged with possession of a controlled substance. You're facing up to a year in jail and or a $4,000 fine. You had court on October 2nd of last year. We issued a warrant for your failure to appear. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge.
Please.
On September 25th, 2024, the officer conducted a traffic stop on East Sam Houston Parkway in Harris County, Texas, after observing the defendant driving 70 miles per hour in a 50 mile per hour zone. The officer requested to consent to search the vehicle, and the defendant consented. The officer found a ball of white capital labeled tramadol on the front passenger seat. The defendant told the officer she did not have a prescription.
Okay. Ma'am, I'm going to find that there's sufficient probable cause to go forward with the case. Can you run her license?
Yes, Judge.
The only issue I have with the case is what's the reason for the search? I mean, she's nothing.
She agreed to it. I mean, that's,
I understand.
Her license is eligible.
okay. As long as you have a valid Texas driver license and liability insurance, you may continue to drive. I am ordering you not to consume alcohol or illegal drugs or unprescribed controlled medication. If I find that you're consuming any kind of illegal pills that are not prescribed, I will put you in jail. Do you understand?
I understand.
You missed court. I'm going to give you a get out of jail free card today, but you're not going to get another one. You miss court again. It's really not going to go well for you. I will revoke your bond and put you in custody. Do you understand?
Yes, sir.
No more PR bonds. You pick up a new case, violate conditions, don't stay in touch with them. That's it. I'm not asking for much.
Judge, reinstatement?
Yeah, we'll reinstate the bond now. I'll leave it at 2501. Get ready because you will be tested. Do you understand?
Yes.
Okay, so,
For the record, it was for her mom.
well,
But yeah, we gotta, yeah, so.
just get it and you guys do what you need to do. I want to make sure that she's just not using. You know, the problem is, and what a lot of people don't understand is they go out, they party, they take these pills. Nowadays, you have no idea what you're taking. Just not even like a little bit of fentanyl kills you, you know? You take oxy, take too much, you put your lungs to sleep, you die. So you got to be careful. I don't know whose, I'm just be careful. That's it. You got but one life. All right. We'll have you sign a reset with Ramona, get you Felicia for your bond condition, Felicia, and then you're free to go.
Thanks, Judge. Have a good weekend.
Thanks, Ray.
I appreciate the effort, Judge.
Okay, Colin, can you hear me?
I can. Can you hear me?
Yeah, I got you.
Super.
So you're saying that there's a problem with the occupational?
No, there's no problem at all, Judge. I got him and he has a 2-year suspension for an ALR. I got that. I got an occupational license for him in November. He pled to a DWI first in December and then met with his probation officer in January. She's decided that she is a license guru and that his occupational license needs to be signed by you. There is no suspension coming from you, Your Honor. He's on
Right, I did
probation.
suspend it.
No, and all he has to do is the DWI education course, and there will be no suspension from you. So she has wasted his time, your time, the CLO's time, and I'm sorry for being here to even bother you. He has no other issues at all. He just started. But he had to take time off work to come here and deal with this because she ordered him.
You didn't represent him on the initial case, did you?
No, Judge, I did not.
It was someone else.
It's George rule.
I remember.
They just want to make sure that occupational is appropriate.
There's absolutely no reason why you need to admonish him, Judge. He's on probation.
I'm not
He
going
has
to.
conditions.
I won't.
I know.
I won't.
I know. I appreciate it.
Do you want, what do you want me to run?
They
I'm
choose
annoyed.
for him to use it, or I can just have him sign it.
And Judge, I don't want to waste your time or the CLO's time. If I can email her personally, and I will CC you and the CLO to let her know what you say about this.
Please include the state so it's not ex parte, okay? Include the state for whatever though.
I'll include the state, but it is an ex parte situation, so
Yeah.
I mean, I guess it's
Okay, I
probation, so-
I approved it, Colin. So,
Okay. I appreciate it, Judge.
okay, man.
Hey,
He's here. Do you want me to let him go?
yeah, if we could.
Shatori's gonna talk to him real quick.
Okay. Hey,
Let
I speak in dichos a lot too. So how do you say? ¿Cómo se dice Chuck, stuck like Chuck?
In what? In
In
Spanish?
español.
I don't know. That's why we got translated, you know?
Good deal. All right,
All right,
Judge.
Brad. Take care, man.
You too. Have a good weekend.
Judge, I know you told James Pond that you were gonna give a PR bond to Alicia Rice, but she had already received a GOB at C-Court. She's only being held on a motion to revoke parole. It's a whole.
Yes, the GOB.
Then leave it. Then there's no need to do a PR bond. If she got a,
It's just a parole.
right, okay. No, you're right. Is James here or no?
He walked out before I could tell him.
Okay. All right, Ramona, you ready?
Yes, Judge.
Let's roll.
Bird, on page 1 and 2. Oh, on page 1, sorry.
Courtney Bird, come up. Mr. Bird, you're charged with 2 cases. You're charged with reckless driving and unlawful carrying of a weapon. On the reckless driving, you're facing up to 30 days and or a $500 fine. And on the gun case, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On March 1st, 2025, at approximately 1:18 a.m., the officer observed a vehicle traveling at a high rate of speed, and the officer had to drive in excess of 130 miles per hour.
130?
Yes, Judge. And the vehicle exited from the highway, and the officer paced the vehicle bumper to bumper between 100 and 105 miles per hour. The vehicle was changing lanes and driving around vehicles that were traveling at the posted speed limit of 45 miles per hour. The officer caught up to the vehicle to get a closer read and paced the vehicle again at 92 miles per hour. The vehicle drove through a stale red light without stopping and into the intersection at 51 miles per hour. A traffic stop was conducted, and the defendant stated he was driving that way because he was on his way to his baby mama's house and that she wanted to go to the doctor. The defendant stated that he may have outstanding traffic tickets. The officer asked the defendant if he had any guns in the vehicle, and the defendant stated he did not. The defendant was arrested for reckless driving, and an inventory search of the vehicle was conducted, and the officers located a loaded semi-automatic gun found between the driver's seat and the center console. The defendant stated the firearm belonged to his girlfriend, and the defendant made further references and threats towards the officer.
Mr. Bird, you understand that I'm going to do everything in my power to protect my public at all costs. And if that means putting you in jail and making your bond sky high, I will do it in a heartbeat. Do you understand? You are not allowed to drive, and you will be signing an affidavit with me today, promising me you're not going to drive. If I find that you do, I can have a contempt hearing every single time you drive. It's an offense in and of itself. Do you understand? And finding that there's probable cause to go forward on the reckless driving in addition to the gun case. You're also ordered not to be in possession of any weapons as well. If I find that you have a weapon, you pick up a new case, violate conditions in any way, I will revoke your bond on both cases, put you in jail, no more PR bonds. Do you understand? Do you have the ability to hire a lawyer? You work these, what do you do with yourself these days?
Yeah, I just lost my job due to this case.
Okay, I'll have you fill out an application. Deputy Rand is going to give you an application. I'll have you fill it out. I'll take a look at it. Keep my county safe. Do you understand? Come on.
Step over here, Mr. Berg. Can you raise your right hand for me, sir? You sworn affirm that you will not give me someone guilty without a valid 65 or something? And no shame. You don't, I mean, you don't have a valid 65 or something?
I have one.
Crump? Okay.
And Your Honor, on further these state's conditions, no weapons in addition to the no
Yeah,
driving.
so no driving, no weapons.
Yes, Judge.
If you can file it, please.
Yes, Judge.
Jamal Crump, come up. Mr. Crump, you are charged with unlawful restraint. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On March 1st, 2025, at approximately 2:27 p.m., the officer was dispatched to a disturbance call in Harris County, Texas. Upon arrival, the officer met with the complainant, who stated that her child's father caused the disturbance and got her kicked out of the motel. The complainant stated her and the defendant got into an altercation due to the defendant trying to take a child away that they have together, and the complainant not wanting to be together anymore. The complainant was attempting to leave the room when the defendant began sitting against the door, preventing her from leaving. The complainant stated she grabbed the defendant by his hair and started striking him with a closed fist because she was in fear for her safety due to a previous offense report from Harris County Sheriff's Office. The defendant called his brother, and the defendant's brother entered the room and started recording the incident, and the defendant was trying to leave with the child, and the complainant attempted to get him away from the defendant. The complainant was unsuccessful, and the child bumped his head on the door, and the complainant stated she knew the defendant by name, age, and sight. The officer was able to locate the defendant's driver's license and positively identified the defendant. Another call for service came from another location regarding an assault that occurred at the original location. Upon arrival, the officers met with the defendant, who stated he was assaulted by the complainant. The defendant stated they were having a conversation in the restroom of a hotel and that he was standing in the doorway when all of a sudden the complainant became belligerent and started cursing him, telling him to leave. The defendant stated he was punched in the face and suffered a busted lip, and the defendant stated his brother was called to mediate and be a witness. Then the complainant began cursing at the brother. The defendant stated the complainant grabbed the child by one arm and threw him on the bed like a rag doll.
Mr. Crump, I'm going to find that there's probable cause to go forward with the case. Did she ended up getting charged as well?
I do not see a charge for the complainant, Your Honor.
So just don't have any contact with this person. That's all I'm asking you to do. You know, sometimes when you have cancer in life, what do? You cut it out, because if you don't, it kills you. Some people in life can become a cancer to you as well. So that's it. I don't want you to have contact with this person. Do you understand? If I find that you do, I'm going to revoke your bond. I will put you in jail. I'm also ordering you not to be in possession of weapons as well, Mr. Crump. You have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer? Okay, I'll have you fill out an application. I'll take a look at it. I'm going to have you sign a reset with Ramona. After that, I'll have you take a seat in the jury box. Do not leave until you sign our bond conditions. Do you understand? Okay, come on. So can you file no contact and no weapons?
Yes, Judge.
Tyler.
A couple quick things I forgot.
Okay.
On the two clients I approached on earlier, I didn't ask you to sign the blood discovery orders. I've had.
I'll put them in. I'll sign everything for you.
Okay, I don't need one to show.
What, is it the standard one, or is it?
Standard.
Okay.
Okay.
So some of the stuff that they've seen already.
We filed it. It's in your queue.
This is just a standard blood discovery.
Standard blood
Okay.
discovery.
Then I'll
order.
sign it.
You will sign them today?
Yeah, of course.
Okay, thank you.
Absolutely. Guys, can you put it in the queue?
They're both in your queue.
For both clients?
Yes, sir. Sorry, Judge, one of those was mine, one was David Smith, so if you see my name.
I got it.
If you can sign the other one as well, I appreciate it.
Yeah.
Judge, next is Frasier on page 3.
Okay. Karen Frazier, come on up. Good morning, Mr. Frazier. Sir, you're charged with indecent exposure. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On March 1st, 2025, the officer was at a Texas Roadhouse parking lot in Harris County, Texas, conducting a traffic stop. While on the stop, 2 restaurant employees approached the officer to state the defendant had just exposed himself to them by having his car window down to be visible to them and stroke his penis up and down. The employees provided a picture of the vehicle, the license plate, and a picture of the defendant. While trying to get an accurate location of the vehicle, the defendant began approaching the employee while she was on foot in the parking lot. Two employees pointed out the vehicle getting ready to leave the parking lot, and the officer conducted a traffic stop. The defendant stated he was trying to get to a hospital for a laceration to his left leg, and the officer went inside the restaurant to view surveillance of the parking lot. The officer observed the defendant waiting in the parking lot before the complainants walked out. The defendant was parked further back than the complainants. When the complainant got into their vehicle, the defendant drove forward and parked next to the complainants. The complainants turned and observed the defendant to have a passenger window down, sitting up in the driver's seat and stroking his penis in an up and down motion. The complainants drove off and came back to the defendant's vehicle to get a picture of the defendant and his vehicle. The defendant pulled forward again in a parking next to the vehicle with a woman facing away from the defendant. The defendant parked his vehicle and eventually drove away. The defendant drove around the parking lot and approached the complainant who was on foot searching for him. The complainant ran away in fear of being hit by the defendant's vehicle.
Okay. Mr. Fleischer, we're going to find that there's probable cause to go forward with the case. I'm awarding you as a condition of your bond not to expose yourself to anyone in this county in public. Do you understand? If I find that you do, I will revoke your bond, put you in jail. No more PR bonds for you. I'm also ordering you not to go back to this place. Where was this?
A Texas Roadhouse, Your Honor.
Okay, you're not allowed to go back to this Texas Roadhouse. Do you understand? Likewise, if I find that you go back, then I will revoke your bond. So would you reach out to them to let them know that we have put these conditions in place so that if they should see him again?
Yes, Judge.
Okay. Mr. Fleischer, do you have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer? Okay. Deputy Miranda's going to give me an application. I need you to fill it out and I'll take a look at it. Don't be a danger to my community. Do you understand? Okay. Can you file those conditions? Oh,
yes, Judge.
No weapons as well.
Yes, Judge.
Mr. Fleischer, you're not to be in possession of any weapons as well.
Okay, Judge, I just texted the complainant.
Yes. But we need to start, getting people out. So after this one.
The next one is Jenkins on page 5.
We're only on page 5. Jenkins, come up.
Wendy Moran.
Good morning, Mr. Jenkins. Sir, you're charged with resisting arrest. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On March 2nd, 2025, officers were dispatched to a traffic hazard. Upon arrival, the officers were monitoring the traffic and crowd control of patrons leaving the bars that were closed around 2 a.m. At approximately 2:20 a.m., the officers observed an altercation occurring in front of D Bar. Officers ran toward the crowd, telling them to stop. An officer approached, crowd dispersed, and the officer observed the defendant punch a male who fell to the ground and was semi-conscious. The defendant and the complainant do not know each other. The officer yelled at the defendant to stop and observed the defendant use his right foot to stomp on the complainant's head while he was laying on the ground semi-conscious. The officer grabbed the defendant and the defendant tried to stomp on the complainant's head again, who was now unconscious. The officers were successful in taking the defendant to the ground, and the officer told the defendant to place his hands behind his back, but the defendant refused and resisted by holding his hands under him in front of his chest. The officer was able to get his right arm out and behind him, but the defendant continued to resist and hold his left arm under his chest while the officers continued to give orders to put his hands behind his back. The defendant resisted and said he did nothing wrong, and the officers were eventually able to handcuff and detain the defendant.
I don't know why an assault hasn't been charged yet. I need to speak with the complainant and the officer to figure out what's going on with that. But yes, there does need to be an assault charge.
Mr. Jenkins, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to go back to this location. I'm going to put an ankle monitor on you so I know where you are at all times. You're not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm giving you a curfew. I don't want you out in the middle of the night. Do you understand?
Sir.
If I find that you violate these conditions, I will put you in jail. I will do everything in my power to protect my public at all costs. 9 p.m. to 6 a.m.
Yes, James.
You're not to have any contact with the complaining witness in this case, not to be in possession of weapons.
This is for you, Judge.
Yeah, not to go within 1,000 feet of this, of D-bar.
Excuse me, Judge. I had hired a lawyer, Miss Timberly Davis, TJ Davis Law Firm. I don't know. Yes, sir.
I don't have anyone here. I don't have anyone that filed any documents. So what we can do is we can reset your case to give you time to hire this person.
I already paid money and everything. I don't know what it.
I don't know why they're not here. I mean, it's already nearly 11 o'clock. Usually lawyers who get here is, you know, she may be, or he may be busy somewhere else. I don't know. So what we can do is I can have you go to Ramona Sanarista. I'll have you get with Fleischer for your bond conditions and we'll just have you take a seat to see if they show. Okay? You know what's expected of you. I don't care who is representing you. I don't care who it is. Small farm animal, you are a danger to my public. I only have one place for you. Do you understand?
Yes, sir.
All right.
I'm sorry, sir. Judge, I see you.
Oh, yeah. Okay, I granted all these.
I don't need to.
No. I just want to make sure you.
Carl, are you taking over for Bradford?
Is that the morning?
The bar, yeah.
Quintavious Bradford?
Yes, it's, they follow knowledge.
Yeah, but you're, okay. Huh?
Yes.
Yeah, okay, great.
Just FYI. Just, you know.
I'm live streaming. I'm live streaming, so I'm live streaming, so be careful what you say.
Just want to let you know, the fugitives we held, all of the we're home at the time they didn't want.
Wow, all that, you know.
It was the TV.
He had TB. They don't.
Oh, he had TB.
Yeah.
What? And we had him here?
Yeah, he was on a 7-day hold.
Oh, Lord.
So,
Okay, well, hopefully he didn't have TB out here.
Yeah, hopefully he didn't affect anybody. We found out after that later.
All right, Ramona, you ready?
Yes, good. The next one is.
Is it Jones? Oh, no, that's,
Miriam Morgan.
Demaria Morgan, come up.
I'm sorry, Judge, not.
Oh, no.
At the bottom, so you can.
Nwobodo, come up, sir. Good morning, sir. Good morning. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 28th, 2025, the officer was dispatched to a crash, and Houston Fire Department was transporting the complainant to the hospital. The officer made contact with the defendant, the driver of the vehicle, and asked for insurance. The officer observed a long neck beer bottle fall out of the defendant's vehicle, and the officer observed an odor of an alcoholic beverage, and the defendant stated he had 1 glass of champagne. Standard field sobriety tests were administered, HGN 4 out of 6, walk and turn 3 out of 8, 1 leg stand 1 out of 4. The defendant consented to a breath sample, and the results were 0.143 and 0.135.
Are you saying that he has alcohol in the car while he's driving?
You're right. They just found the bottle on the driver's side. There's no indication of being cold to the touch or anything like that.
Driver's side where?
Of the vehicle. It just said it fell out of the driver's side. When the full DIMS just says they observed a long neck beer bottle fall out of his vehicle on the driver's side. And that's the only thing that it mentions.
Can you run his license, run him, see if he has any prior DWIs, please, and then his license?
Your Honor, he has no priors and his license is eligible.
Mr. Nwobodo, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. Do you understand? You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you don't have car insurance, likewise, you're not allowed to drive. We are going to reset your case to give you time to hire a lawyer. So I will have you go to Ramona, sign a reset. After that, you'll get with Fleischer for your bond conditions, and after that, you'll be free to go. When you come back, please have a lawyer, sir.
There's some mock conditions for signing the communicator.
I second.
Okay, so well.
Ms. Ford, come up. Queen Ford. Thanks, Deputy Miranda.
Simon, Nick.
And I think he's done away, right? So I think he's ready to go after this.
Oh.
Yeah.
Right here, sir.
Yeah.
I'm gonna have you sign your state bond conditions that you. Yes, please.
They're not gonna do it. Yeah.
I'm gonna have something out for you to have the shape of the.
Okay. Thank you.
Good morning, Ms. Ford.
Morning.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed for you, ma'am.
I apologize. What's the last name, Your Honor?
P-O-U-R.
Okay. On March 2nd, 2025, the officer was dispatched to an accident on the 4500 block of Southwest Freeway, and the defendant was passed out in the passenger seat of a tow truck. The officer noticed that her eyes were low, her speech was slurred, and her breath smelled like alcohol. She had also urinated on herself. The defendant stated she had one drink and was coming from a club, and the defendant showed lethargic behavior, and the defendant confirmed that she was the driver and that no one was with her. Standard field sobriety tests were administered, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant consented to breath, and the results were 0.128 and 0.118.
Where was she driving? What was she doing? All I know is that she's sitting in a passenger seat of a tow truck. How did she get there? What happened? Was there an accident? Who is writing these reports nowadays? I mean,
yes, Judge. And the statement made statements stating that she confirmed that this was her vehicle and she drove it to the crime scene. The defendant confirmed that she was with only her and no one else was with her. The defendant confirmed that she was on her way home from a club where she consumed alcohol, and the defendant's vehicle was found stalled on the shoulder of a busy freeway. And the officer wrote that led the affiant to believe that that there was no one else that fled from the scene. And the officer wrote from the affiant's training experience that he believed that the defendant was the driver of the vehicle based on the statements made to him and finding the vehicle.
did anyone see her drive? Did the tow truck driver see her drive? How long did she drive? When did she drive?
We don't have that information. So it says that there was, Deputy DuPont was dispatched to a one-car minor accident and the vehicle was leaning on its side and stuck in a muddy ditch. The defendant was passed out in the driver's seat with the key inside the ignition and the engine running. That deputy spoke of the defendant.
So someone sees her in the ditch.
Wait, I think you might have a different.
That's a
Oh, sorry,
different
that was
case,
the
right?
wrong case, Judge.
In this
Sorry,
case,
sorry.
she was passed out in the passenger seat of the tow truck, and there's no other information in regard to her driving besides the statement she made. So there's no one that observed it, Your Honor. And we understand.
Let's do this. I'm gonna appoint you a lawyer today so we can have someone take a look at the case for you. Okay? Ramona, do you mind appointing someone for Ms. Ford, please? Just do me a favor. Just take a seat for me in the jury box, will you, please? We'll come back on that.
Yes, sir.
Ashton Jenkins.
Judge, Miss Davis is on.
Good morning, Ms. Davis.
Good morning, Your Honor. How are you?
Pretty good. Have you heard PC on your case yet?
No, sir, I have not. I've been on hold though but I haven't, they
So
just let me in.
Let's do this. We'll have, is it, Ramona, who was it?
Jenkins.
Come up.
Ashton Jenkins.
I'm right here, sir.
Come on up. Your lawyer's here now. We're gonna do probable cause again so she can just hear what happened.
All right.
Okay, do you mind?
Yes, Judge.
Please.
I'll state it again. On March 2nd, 2025, officers were dispatched to a traffic hazard. Upon arrival, the officers were monitoring the traffic and crowd control of the patrons leaving the bars that closed around 2 a.m. At approximately 2:20 a.m., the officers observed an altercation occurring in front of D Bar. Officers ran towards the crowd, telling them to stop. As officers approached, the crowd dispersed, and the officer observed the defendant punch a male who fell to the ground and was semi-conscious. The defendant and complainant do not know each other. The officer yelled at the defendant to stop and observed the defendant use his right foot to stomp on the complainant's head while he was laying on the ground semi-conscious. The officer grabbed the defendant, and the defendant tried to stomp on the complainant's head again, who was now unconscious. The officers were successful in taking the defendant to the ground, and the officers told the defendant to place his hands behind his back, but the defendant refused and resisted by holding his hands under him in front of his chest. The officer was able to get his right arm out from behind him, but the defendant continued to resist and hold his left arm under his chest while the officers continued to give orders to put his hands behind his back. The defendant resisted and said he did nothing wrong. The officers were eventually able to handcuff and detain the defendant.
He is, at this point, only charged with the resisting. I don't know if they're going to do any further charges in the future for the assault. I have ordered him as a condition of his bond not to go back to this location, not to consume alcohol or illegal drugs, and I put a monitor on his ankle so I know that he's not going to go back and that he's not out in the middle of the night. I have given him a curfew because I just, you scare me, and I don't want you out in the middle of the night.
Well, Judge, if I can, when you're done, Judge, you know I don't want to interrupt you, but if we can consider, because he hasn't been charged with anything else, what I did hear is I hear that these officers arrested him that night, and I'm quite sure that whenever they called DA intake, they ran the facts down just as they wrote in the DIMS. So, and the reason I'm asking that we not, so I'm interested to see whether or not the charges were outright denied, or whether it was referred.
They were
And because we don't.
All charges were refused, and I've reached out to the intake ADA to see why they were refused.
I mean.
And so I guess the only thing that I was asking, Your Honor, is because they were refused, what we don't know is the back and the front and the forward and all the other in between of this. So I am asking if an ankle monitor not be done on just a resisting arrest and a curfew not be done on just a resisting arrest.
I'm going to do it just for now. If I see that he can behave himself for a while, then come back and we can talk. But for now, I don't want him out in the middle of the night.
Can we just say he not go out in the middle of the night, Your Honor? But I mean,
no,
the only
because
reason
I don't, then I can't see that he's not doing it. I'm going to pay for it. So it's really, I'll pay for everything. So money's never an issue. How do I know that he's actually sticking to his word? I won't. The only way I know is a monitor, and I'm going to do everything in my power to, protect my community. If that means keeping you at home at night, that's what's going to happen. So, like I said, Ms. Davis, you can always come back after some time. We can discuss. I can, for the life of me, understand how they would just deny. I don't get it. But
I guess when my only thing is, Judge, and I guess I'm urging it because if we have an ankle monitor on, and I understand your fears, the charges have been reduced. If we're going to look at it in terms of being safe for the community, something could happen in the daytime. I just don't want to put, and I'm asking, a restriction on somebody who can't go to work, who can't go get Pampers, who can't go get milk. Emergencies from the middle of the night.
I did 9 p.m. If you want, I could do 10 p.m. I'm always willing to work around a schedule for work, but I'm going to put it on you. That's it. I don't want you out in the middle of the night. I don't want you going to bars. I don't want you going to clubs. I don't want you using alcohol, illegal drugs. That's it.
I get you. I got you.
So we'll come back after some time. Any more issues? Talk. I'm always ears,
I know you are, Judge.
And then,
thank you, Your Honor. I appreciate you for listening.
For sure. And so you want 9, you want 10, whatever you want.
If we can do 10, Judge. Mr. Jenkins,
okay.
I guess I did not foresee this on just a resisting arrest, Judge. What are the hours you work?
Currently, right now, I'm at Exxon Mobil in Baytown working 6 to 6. I work overnight. I just got off work coming here.
That's a problem.
I can
and
talk,
so that,
talk to my job. I got you.
That's why I was, and so Judge, that was why I was concerned. I knew that he worked. His sister used to work for me as a paralegal. And so I knew that there was some nighttime going on here. I just, I didn't know, I didn't anticipate this, so I would have had my issues together. Can we make it to where he is only to go to work at whatever day?
For now, I don't know him. I don't know how he's going to be. Let some time pass and then we'll come back, talk to your work. Yeah, I don't want to prevent anyone from working, but.
So is he able to at least go to work, Judge, and take the curfew off and say that he is to only go to work? Because if you
No,
have an ankle monitor
how do I know
on-
he works? How do I know he works in the middle of the night?
No,
Other than
what I'm
his
saying
work.
is, judges, if he has the ankle monitor, Your Honor, then you can see him leaving from his house to his job.
No, Miss Davis, how do I know he actually works in the middle of the night? I have no proof of that.
Well,
Okay,
okay,
other
I'll
than
tell you
him
what,
saying
Judge,
it.
can I come and bring you a check, do you have anything on your phone right now, Mr.
I
Jenkins?
got check stubs right now.
I'm not, I will, you guys do that at different time.
All right.
I mean, I have a lot of business that I still got. I got another courtroom
Okay.
full of people still to deal with. So
Can I
come back
approach you
and we
next
can-
week on it, Judge?
Absolutely.
Yes, sir.
100%.
I'll approach you next week on it.
For
Your Honor.
now,
I got it.
no out in the middle of the night.
Yes, sir.
Okay.
Appreciate you.
Come on.
Thank you.
So Timothy, give me a second. I'm gonna get your date.
Thank you, Judge.
Or you tell me, I guess, tell me what day you want.
I was just gonna come off docket, Your Honor, next week. I'm gonna
Okay.
get him to send me a photocopy of his check stub so I can present to you, because I don't want him to lose a job on a misdemeanor resisting arrest. I just need him to work. He gotta pay me. So I
get it.
I don't want him to lose his job. You know, it's already hard enough for men, especially Black men, to get jobs, especially with this hanging over his head. So he may lose his job, and plus he may have a situation where he can't go out and perhaps get another job.
Hey, you want to get together Monday? I'm happy to do it. I'm
Yes,
here
I
Monday.
will do that,
So,
Judge. I'll
whatever
be
you
there
want.
on Monday
Okay.
in person to show you.
All right.
Thank you, Judge.
Bet.
So his appearance is waived.
It's sure.
And Judge, we will be filing assault charges on this case at the time because the complainant was unconscious. He couldn't state whether he felt pain or not.
Did you hear that? That's
Either
why
way,
charges
Judge,
are
I
none.
just, if they're gonna file, I just need, I'll do my research on it. They can contact me, let me know, but either way, I just want to talk at least about him working. That's the
Yeah.
very least. And then I can get a regular court date for him later with Ms. Bernal. But I at least want to come in to talk to you about him being able to work,
Okay.
and show you some proof, if I can. Okay,
Done.
so Ms. Bernal,
All right.
whatever date is good. I think I have another case in your court coming up. Can we email you what date that is so I can put both of my cases together?
But
And
do
then
it with
I'll come.
Ramona. Ramona's here today. It's not Victoria. So
yes,
email
sir.
Ramona.
I'll have
Okay.
the court call, my office call Ms. Ramona, and then I'll be in personally judge in person.
Okay.
Thank you. Bye-bye.
Hey, wait, we need you to file an attorney record too.
We filed actually, but I'll get him to refile it. I'll get him to refile everything.
Hold on, Timberly, I'll see.
Thank you, Your Honor. We filed an appearance of counsel.
This is on. Margo.
Jenkins? You would say somewhere? No, we haven't.
Bottom of
I don't
five.
see him, I don't see him in here. Let me see if it's probably.
Pending, maybe?
No.
No, I need to file one.
Yeah, you needed to file it because they don't see it.
I'll have my office. I thought they did, but I'll follow up, Your Honor. No problem. You know, I'll take care of it.
Not a problem. Okay,
I'll
Timberly.
take care of it. Okay.
Okay.
Thank
Have
you. Can
Yes,
I be
ma'am.
excused, Your Honor, or do you need me to talk to Miss Ramona on the phone?
We're good.
Tell her to put it in the chat.
She's in the chat.
Will do.
Okay. All right, that way.
Just take a seat and then I'll bring you next.
So Judge, the next one is Samuel's on page 13. Bobby Samuel.
Bobby Samuels, come up.
Sign bond petitions, Judge.
Yeah.
Oh,
Jamal
Herrera?
Crump. Jamal Crump.
I think his attorney has to talk about it.
Okay.
You are Mr. Samuels.
Yes, sir.
Sir, you're charged with failure to identify oneself to a peace officer while being a fugitive from justice. who are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 28, 2025, the officer was dispatched to a suspicious person call on Montgomery Road in Harris County, Texas. The officer arrived on scene and was informed by the caller that there was a male at the above location that had a warrant and that he was sitting on the steps in front of the apartment. When the officer arrived, he did not observe a male on the steps, so he knocked on an apartment and the defendant answered the door. The officer told him he received a call at the location and asked him to identify himself. The defendant stated his name was Levante Samuels with a date of birth of December 7th with no year given. The officer had officers on scene run the defendant NCIC, TCIC, and nothing came back. The officer asked the defendant again for his name, and he informed him the same name. An assisting officer on scene informed him that the defendant was the wanted person, so the officer detained the defendant. The officer placed the defendant in handcuffs and thoroughly searched him before placing him in the back of the patrol vehicle and was shown the defendant's mugshot and asked the defendant again if he would tell me his correct name. And he proceeded to tell the officer that I already got it. So I asked for a unit with a mobile AFIS, and the officer used the mobile AFIS and was waiting on the defendant, who then stated his name was Bobby Samuels. The officer then had dispatch confirm the warrant, and the defendant stated that he had told him the wrong name because he knew he had a warrant. The warrant was confirmed, and the officer took the defendant into custody.
So you had an open, what, felony warrant?
I'm trying to find what it was. It was an AFM warrant, an assault family member. I'm trying to see where it's.
It's a felony warrant.
It's a felony warrant, Your Honor.
Mr. Samuels, I'm going to find that there's probable cause to go forward with the case. I'm not putting any conditions on your bond. Just be careful. Don't pick up any new cases. I'm going to protect my community. If I find that you pick up a new case, I'm going to put you in jail. Do you understand? No more PR bonds. Do you have the ability to hire lawyers, sir?
Yes, sir.
Okay, I'll have you fill out an application. I'll have Deputy Miranda give you one. I'll take a look. I'll have you sign a receipt with Ramona. We'll have you fill out the application. I'll take a look, see whether you qualify.
Okay, go ahead. The next one is on page 13.
Got it. Hi, front shake. Come up.
Judge, we do see anyone at.
Just Frasier, which I granted.
Good morning.
Your front, is it Shake?
Yes, sir.
Sir, you're charged with 3 cases. You're charged with terroristic threat of a family or a household member. You were charged with assault of a family member. You were charged with interference with emergency request for assistance. All 3 of those, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Can I say something or no?
About the case, or do you have a lawyer?
Obviously, attorney, yes.
I'm sorry?
I was attorney and I need to discuss something, sir.
You are an attorney?
No. I need attorney. I need attorney.
I need hair. We'll talk later. Let's do probable cause first. You have the right to remain silent.
Yeah.
Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On February 23rd, 2025, in Harris County, Texas, the officers were dispatched to a threat to life call. Upon arrival, the officer met with the complainant, who stated that the defendant is her husband. The complainant stated that the defendant and her got into an argument, and that the defendant stated, "I'm not afraid of the police. I will grab that knife and cut your throat." The complainant then stated that the defendant had on November 16th, 2024, assaulted her. The complainant stated that the defendant grabbed her by the top of her dress, causing scratch marks, and punched her in the chest, causing bruising. The complainant stated that she attempted to call 911, but the defendant ended the call.
Sorry, patience.
The terroristic threat was I'm going to grab a knife and cut your throat, Your Honor. Okay. Mr. Sheikh, I'm going to find that there's sufficient probable cause to go forward with the case. Do you have the ability to hire a lawyer?
So this also is attorney. Whatever money I have.
I'm not going to listen. You have the right to remain silent. exercise that right. Anything that you say, they're going to try to use it against you to prove guilt. So what I can have you do is I can have you fill out an application. I will take a look at it to see whether you qualify. We don't give appointed lawyers like it's candy on Halloween. You have to qualify. And if you do, then I'll take a look. But I need you to fill out everything. As it stands now, I am ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. You are not to go within 200 feet of where this person lives or where this person works. Do you understand?
Jamal Crump?
Do you see whether a order for protection has been entered in this case? Guys, let me see.
And Judge, the DVD prosecutor is on the phone.
Oh.
There he is.
That's
Yes, Judge, I was able to make contact with her. I'm not sure what the discussions were beforehand, but we're gonna be asking for no contact with to keep the whatever the residency restriction is in place right now.
She does not want to have contact with her. Okay.
And I don't see a protective order in place.
On the AFM, there.
Is there one in the AFM?
Yeah.
But I'm going to also do one on the terroristic threat.
Yes, Judge.
I want you to understand something and take me seriously when I say this, that when I mean no contact, I absolutely mean no contact. I don't care what's going on in your life. I don't care that you need clothes. I don't care that there's a child involved. I don't care that you need to go get the car, whatever it may be. No means no. And if you violate these court orders, the state can and probably will file a violation of a protective order against you. That is the capital murder of misdemeanors. Do you understand? I am now entering in what's called a magistrate's order for emergency protection on the terroristic threat. This is a court order that identifies the complaining witness as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where she lives or where she works. You understand? This is what I'm saying, that if you violate this order, they can file additional charges against you. Now, Deputy Miranda will give you an application. I'll have you fill it out. I will take a look whether you qualify. Anything else you want? Oh,
No, Judge, we're comfortable with no contact.
so can you also file the no contact and no weapons so that it outlives the, okay. Do not leave until you sign our additional bond conditions.
Yes.
Okay, please. Can you file a MOA on the parasitic threat? Because I don't see one that's been filed.
There's not a motion filed on this one.
Okay, yeah.
Please. Yeah.
Judge, on Jamal Crump, you ordered him to have no contact with the complainant. They share a son together. Is there any way they could have a third party for visitation?
Well, of course. They can always use someone else, but I don't. Come up, Mr. Crump. I know that you're upset that they filed this case. But when I mean no contact, I absolutely mean it. They're going to call this personnel to let them know of the bond conditions that have been filed. So if I get wind that you have contact with this person, then we're going to have issues. I get that you have a son and you should have, or a daughter, I don't know what it was, but you should have access because every father should have access to their child. And I want you to have access to your child, but you got to do it the right way. You know, use someone who like James is saying, a third party. Don't take it upon yourself to try to do stuff because it's going to go sideways real quick. Maybe if you have parental figures like your mom, your dad, someone that she probably likes, right? If she doesn't like your brother, that's probably not a good person to use to try to get contact with the child. So try to find someone, you know, maybe he can also help you too. You know, maybe he can help facilitate as well, where she drops off the child at a McDonald's somewhere, and then you come and you get the child for a certain amount of time, and you drop the child back off at a McDonald's. But don't do stuff your own way. Are we good? Okay.
Thank you, Judge.
Yeah.
Judge, next is there on page 16.
Okay, coming up.
You're back.
Good morning, Mr. Ma'am, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. Officers were dispatched to Fairmont Parkway in Harris County, Texas, and the defendant was arguing with her husband in the parking lot and got into the car and drove off, nearly hitting him and causing him to fall to the ground. Witnesses called the police, and officers found the defendant in her vehicle near the exit with the car in drive. The defendant ignored the officer's request to turn the car off, and officers noted slurred speech, red eyes, and unsteady balance, in addition to an odor of an alcoholic beverage. Standard field sobriety tests were conducted, HGN 4 out of 6, and the defendant refused the remainder of tests and was transported to JPC. The DIC was read and the defendant refused. A blood warrant was signed and executed. During an inventory of the vehicle, the officer located 2 stemless wine glasses. The glasses contained a small amount of a red liquid smelling of an alcoholic beverage and showed recent signs of consumption. The defendant's purse was located in the front passenger seat and was stained with the red liquid matching the hue of the liquid in the glasses, still wet and smelled of a fruity alcoholic beverage.
Mr. I'm going to find that there's sufficient probable cause to go forward with the case. I am now ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I am now also taking away your privilege to drive. You are not allowed to drive. Do you understand? If I find that you do, I will revoke your bond, put you in jail, and I'm going to make it high. You will be signing an affidavit with me today, promising me you're not going to drive. It doesn't matter what you need to do. Do you understand? Not only that, I'm now placing a restriction on your license that you are not allowed to drive any vehicle that is not equipped with an ignition interlock. I send this order to DPS so that every single officer in this state knows you get pulled over, they'll look you up. They'll see that you need an interlock in your car. And if you're caught driving one that doesn't have one, they will take you to jail. Can you run our NCIC, please?
Yes, Judge. So she only has the one prior from 2000 at a Fort 5 DWI, no other prior DWI.
Okay. Do you have the ability to hire a lawyer or would you like to apply for?
I'd like to apply for a court appointed.
Okay. Deputy Miranda's going to give you an application for an appointed lawyer. I'll have you fill it out and I'll take a look to see whether you qualify. I'm going to have you come up here, swear to us that you're not going to drive. I will get you to Ramona where you will sign a reset. You will get with Fleischer if your bond conditions. I don't know if you have a problem with alcohol or drugs. If you do, now is the time for you to address it. Because if I see it becomes a problem, I will address it for you. And I promise you're not going to like the way that I do it. Do you understand? Okay, come on. Top of page 16.
I don't have a dog.
Oh, stare.
Thank you.
Do you need a cause number?
No, I don't.
Okay.
I'm gonna swear you into the health charge now, so just raise your right hand. Do you swear from the new law, both of your care against this driver's license? Yeah. No. To do is engineer.
Judge.
Okay, Ramona.
We have one that's on page,
Oh, that's it?
we have Mallard on page 7, but I see an attorney attached. I don't know if you want to go ahead.
I mean, it's already 11:30. They're not here. I don't, yeah, we need to like,
Mr. Mallard, come on up.
oh, this is the same thing. I see that you have a lawyer. I don't know where they are, but we need to get cooking. So, okay. So, Mr. Mallard, you're charged with 2 cases. You're charged with driving while intoxicated, second offense. You're also charged with resisting arrest. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On March 1st, 2025, at approximately 11:08 p.m., the officer was dispatched to a 911 call regarding a vehicle stopped on the road with the male in the driver's seat passed out on North 8th Street in Harris County, Texas. The officer observed the defendant's vehicle stopped on the road facing the wrong side, forcing multiple vehicles to drive around the defendant's vehicle. The officer observed the defendant's vehicle's engine on, with the defendant sitting in the driver's seat, appearing to be sleeping or passed out. The vehicle was in drive with the defendant's foot on the brake. The officer observed an open container of Bacardi rum, 750 milliliter bottle, approximately 10% full, sitting in the front right passenger seat, and the officer attempted several times to wake the defendant unsuccessfully, which led to the officer being forced to break the defendant's front right window to get into the motor vehicle due to the doors being locked. The officer placed the vehicle into park, and the defendant was asked to step out, who immediately fell to the ground. The officer observed slurred speech, red bloodshot eyes, a strong odor of an alcoholic beverage, and poor balance. The defendant refused any standard field sobriety test, and the defendant advised he had not consumed any alcoholic beverages, wished to speak to his lawyer, and was loudly repeating no consent to all questions. The defendant was read the DIC and refused breath. A blood search warrant was signed and executed. The defendant was transported to HCA Southeast ER to obtain blood, and the defendant refused to exit the officer's motor vehicle, even when the officer asked multiple times. The officer had to physically guide the defendant out of the vehicle, and the defendant stopped walking while walking to the ER with the officer and advised he wanted to go to the Veterans Hospital. The officer advised the defendant he had a search warrant, and the defendant refused to move. The officer grasped the defendant's upper arm and advised the defendant again of the search warrant, and the defendant refused to move. The officer advised the defendant that if he had to pull him inside, he was facing additional charges. The defendant again refused to move. The defendant advised he wanted to go to the VA hospital, and the defendant started pulling away in the direction away from the entrance to the hospital. The officer attempted to pull the defendant to the entrance, and the defendant continued to pull away. The defendant went dead weight and laid down on the ground outside and refused to move while screaming at the top of his lungs, "Someone help me." The officer was assisted by hospital security in placing the defendant in a wheelchair, allowing transport into the hospital, and the defendant's blood was only able to be drawn with assistance of 3 officers holding the defendant down.
My goodness. Can you run his NCIC? Does he also have a felony DWI with a child as well?
It was reduced to a DWI just above a 0.15.
If you have a problem with alcohol, you better address it, Mr. Mallard, because if you don't, I'm going to do it for you. I don't want you out in the middle of the night, and I'm now giving you a curfew. You are not allowed out past 9 p.m. to 6 a.m., and I'm going to put a monitor on your ankle so I know that you're not out in the middle of the night. On your other ankle, I'm going to put a scram monitor so I know that you're not consuming alcohol. Likewise, I don't want you to drive. I am now taking away your privilege to drive as well. You're not allowed to drive. Do you understand?
Judge 96?
Yeah.
Raise your hand. Raise your hand.
Heed this warning. If I find that you drive, I can have a contempt hearing. Every single time that you drive, it's an offense in and of itself, punishable by up to 6 months in jail and a $500 fine. Do you understand? I don't care what the justification is. Jesus comes, needs a ride to church. I don't care. Do not lie.
I was trying to read what I was referring to this.
I am also now placing a restriction on your license that you
Excellent. That's all very, cool. I couldn't see them.
I'm now placing an additional restriction on your license as well, that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle, number one, we're gonna have issues with this. Number two, I'm sending now notice to DPS in Austin so that they know any vehicle that you drive is supposed to have an interlock in it. So if you're caught driving a vehicle that doesn't have an interlock, they will take you directly to jail. Do you understand? At this time, you're not allowed to drive. So you will get, well, you got the scram, so I'm not going to give you a portable device, but I don't want you drinking at all. This thing is extremely finicky that they're putting on your ankle. So know what you put in your body. Do you understand, Mr. Mallard?
Yes, sir.
If I find that you consume alcohol, anything that has alcohol in it, cakes, candies, foods, gums, energy drinks, hair dye, I've heard it all. If I find that you're consuming, it's really not going to go well. So I'm going to have you come up here, swear to this. After that, I'm going to get you to Ramona, where we will have you sign a reset. I will have you get with Felicia if your bond conditions, and then we'll have you take a seat while we wait for your guys to get here. Come on. Great. Okay. Thank you, Sebastian.
Do you want to correct the note that's already filed for the AFN?
What do you mean, correct?
There's a note that's already signed that
I want
includes contacts. Yeah, includes contact, just not
I think the new one, I put in the specific good cause, with questionable contact.
You put it in the new one.
Okay.
So I guess you could write, if you want to print it out, I'll write no contact in the old thing too. So just, it's, you print it out, let me write it in.
Okay.
Judge, for stare, a portable device as well.
Correct.
Okay, go ahead.
Ms. Strong.
Yes, Judge. I have an
Hey.
off-docket matter. I just filed jail release instructions for Antonio Townsend. Brad
Okay.
Morse is dismissing the case. He just wants you to sign first.
Got it. Did you? Okay, I'm signing it right now for you, Ms. Strong.
Thank you, Judge. Have a good weekend.
Hey, and next time, so you don't have to sit here and wait, just type it up, put it in the chat, and I'll know, and then I'll get it done. That way you don't have to just sit here and wait.
I
Okay?
appreciate that. Thank you.
Yes, of course.
Before I sit down. Right.
Are you gonna do anything with Velasquez?
So, from what I understand, the Hickler wants us to do an eval on all DWI cases that are in the RPC before
Okay.
we dismiss them.
So if you want to let them know, do you speak Spanish? Okay, so if you want to let them know that they're free to go, no probable cause. They haven't dismissed the case because they're going to eval it, but I guess have them keep checking on the website to see whether it gets dismissed, yeah, or not. But they're free to go.
Oh, right there. And just stay here. This is your monthly salary. I just want to make sure it's monthly. It needs to be monthly. And then give me a total down here for your expenses. Okay.
Judge, no bond conditions on Frasier.
What? That's the indecent exposure.
No, there. Okay.
Yeah, it states conditions. Guys,
I thought I did, 1 second, let me,
We're checking this, Judge. Let's go through the.
no problem. Hey, guys, who's that in the green shirt?
You got him? Frasier, yes. Did y'all get him?
Yes.
Okay, sorry.
Sounds familiar. Let me see.
This is just more.
Yeah, then Mr. Shane.
Oh, that's right. That's it. Right now. Yes.
Hey, Ramona,
I'm sorry, Judge.
we have a Weber in the audience now.
Yes, and I've emailed Abel and he has not responded.
What's it about?
Yeah, so he bonded out. He was in custody, but he bonded out. Yeah.
I get, you want to give me cause number and let me see.
It's on the jail doc.
Oh, it's on, okay.
It's almost there, but not.
Morning, y'all. We're approach.
Yeah, yeah.
You have a moment.
Come on.
Yes, Your Honor. Okay. So we're approaching on, I'm sorry, first, good morning. We're approaching on Ms. Duvernay, Stormy Duvernay. This is the one you talked to, I think, on Wednesday.
And
they're recommending Hue.
Wonderful.
And I told her that probably is what they were going to recommend before she even came in. So she already had her mind going that way.
Right.
And she's okay with that. I don't think the state's
And I think
opposed.
that that's probably the right course of action, you know, and I think that we should do it.
Yes, Your Honor. So the next question is how do you want to handle the probation?
Extend it.
Okay.
We'll extend it and then at least a year.
So I think November, Your Honor, should be at her 3-year mark.
Well, like, extend it to November. You know.
That's
And then
what the
we'll
conversation
go-
we just had before we came up.
Yeah, we'll go from there. I mean.
I'm like, I think she's getting kind of close. All right. Thank you, Your Honor.
Is it 6 months?
Correct.
Okay.
So normally it's 3 months
She
inpatient,
does
3 months
well.
aftercare.
Okay.
Raise your right hand.
All right. Thank you, Your
Okay,
Honor.
thanks. How long of a, is there a wait?
About 2 weeks for now, I can rush you.
You're the best. I don't know what to do about Abel. I guess I'll call him, Ramona.
Well. We should be logging.
Or is he logging in? Okay, great. Carl, you want to talk about something? You want to talk about something?
Do I want to talk about something?
Yeah, great. You look like you needed to approach.
No, I was talking about
Okay.
but I do want to talk.
Let's.
I mean, you can check about
I do let me know when she does. I'll understand whenever they call.
She was signed, I don't think she's signed.
Okay, so you let me
You're an intern, yeah. Okay, what year y'all graduating? I have one back. Who graduated? Excellent.
No, he was diagnosed.
Okay, so my wife, if she was still alive, will graduate till 80. Oh, okay. And with that, I want to have fun someplace.
Oh, you were like, sure, he picked up medication. So he hadn't been diagnosed before March 3rd.
And we had in March.
And 2 weeks.
And I'll reach out to.
The only way we know is I know that, so the girlfriend called me and Oklahoma. So I figured trying to say those.
Who's this, Rice?
Yeah.
Yes.
Is your name Judge Macro?
Yeah.
I was here
It's okay.
earlier. I have two off-docket motion of subs that I need signed.
I'll sign it for you. Just have them put in the queue. And then what about our, you want to do our thing now?
Waived extradition.
Oh, you did?
They were in touch with Pennsylvania. Pennsylvania actually wanted to come pick them up yesterday, but we had this set. So they're gonna try to pick them up tomorrow, so we should be good. Yeah.
Okay.
All right, thanks, Judge.
I'm Ramona. Shake, I'm granting it. Anna, please. Whoa. Double team. Hi, Harold. How are
Well,
you?
they've got two over there too, so.
Friday.
We're approaching on Mickey.
Nikki?
Yes, he's in custody.
Okay.
He's got a fugitive case and then he's got two local cases in this court as well.
So I'm assuming one represents one on the fugitive, you,
Cases.
okay.
Hey, Judge, we're gonna ask if, since he has a parole holder from Louisiana, if you'd be opposed to withdrawing not revoking, but drawing the PR bonds and setting a money bond for him.
Sure.
That way he wouldn't be snatched out.
Credit regardless. If someone's in custody, even if we don't have a hold on them, I always give the credit regardless. I'm happy to do it.
Well, and
but
Judge, the other
We'll
issue
raise it by $1.
is if he goes to Louisiana and bonds out, he has cases here and there and getting back and forth, just setting someone up for failure.
Right. So revoke it then?
Well, could you not revoke it, maybe withdraw it? Is there a way to do that without punishing him? Withdraw
the PR bonds?
We can ask you to reinstate it.
It just, we didn't want a situation where you set up a stare facious.
This certain order from Sylvia Cherry, and last time we tried doing that, it was weird. If we ended up bond revoking it later on because it never went through.
I don't know how, theoretically, I don't know how you would, because I have to have, so what would happen was I would revoke the GOB.
Yep.
And we'd basically have him sit on $100 bond that he just can't make.
Right, but if things were to change or his local cases were dragging out, we could come back and ask you to reinstate the PR bond. Because it's not a true violation, we're just doing it to keep him here to resolve his cases.
Sure.
And can you revoke?
But like I said, I'll give you the credit regardless. If you want to leave it now as is, he's in custody, I'll give you the credit regardless, or.
Well, he signed the waiver and it's Louisiana, so they're gonna come get him.
And can you, if you revoke those, Judge, can you do it in a way that we don't they don't initiate the stare facious to go after him for the bond amount?
They wouldn't. They won't. I haven't seen it in years.
I see them all filed, everybody's cases.
I haven't signed one in 5 years, 5.5 years. I don't even see them filed like they used to, number one. Number two, if I revoke the bond and it puts a hold on so we better not do it, because if I revoke the bonds, it puts a hold on Louisiana.
Well, that's what we want, Judge, so he can resolve the cases here. Because if he goes to.
Then I have to revoke the bond,
And then-
because if you want to resolve these cases here first, I have to revoke the bond, because Louisiana is going to come and get him if there's no holds.
You know what, and he's here because he's arrested, that's right, because
Yeah.
as long as you're rearrested within 6 months, then extinguishes the,
So if you guys don't want him to get took, I have to revoke the bond.
that's fine.
And I can just raise it by $1. And then once you resolve it, we can reinstate it. And then that way Louisiana can come and get him.
Sure.
Because I'm telling you, Louisiana comes once, twice a week. So he'll probably be gone by Tuesday if I leave it like this. How long's it been on?
The cases here, the cases there.
Hmm?
If Louisiana comes to get him on Tuesday, which they very well might, he'll have the cases there to deal with, the cases here. And if he's going back and forth, that's just asking
The
to.
problem, the
miss-
issue is, the other issue is this, is that a lot of times you will say, hey, guys, you got to stay in contact with me, right? And then they don't. We end up revoking the bond here because he's in custody over there and he can't get a hold of you, right? So it's a complete mess. So you're really much better off resolving these cases now so that when he goes back to Louisiana, there's nothing here.
Right.
Because invariably what always happens is we end up putting a hold here and then this reverse situation happens over there. Why don't we revoke it? I mean, it's only a trespass and evading, right? What is it, capital case? No, you know?
No, that'd be fine.
Capital trespass?
That'd be fine. And then to just stay here till we work them out. And we're working on how to work it out, which will make sure
I
it's not
mean,
gonna hurt.
I'm not sure. It's not gonna take forever, right?
No, I would hope not, but I'm sorry, I couldn't.
Do you have an offer on these cases from this
We
meeting?
don't, it just came in yesterday,
Right.
but I
I know.
can do my best
Reasonable
to,
with
yeah.
them too.
Our only hesitation is that she has to put on an offer before we have a accurate summary of what's going on, but it looks like the videos did come in, so I'll take a look, see if we can get something on.
Can you go ahead and share it to them so they can get access to it? Okay. So, so 101? Is that okay?
That's fine.
Okay, so do you mind? Okay, and then just let me know once you get, I'll go however you want to go. Just let me know.
Okay.
Yeah, okay. Thanks, guys. Sure. Thanks, Counselor. Okay. Ramona, I'm gonna stare on Granny. Here. Good morning, Ms. Rice.
Good morning.
Ma'am, you're charged with failure to identify oneself while being a fugitive from justice. That makes it a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 24 days in jail with credit for the 8 days that you've done. You need to understand there's a couple very serious points now. Number one, this is going to go on your record. It will be there forever. From now on, you're facing a minimum of 90 days in jail for any new cases that you pick up. The other thing that you also need to understand is that you're on parole. It's very possible that because you're on parole, by pleading guilty to this, it may result in further confinement. I don't know for sure. They may send you to ISF, but they really could send you back to prison because of this.
Yes, sir.
Knowing this, do you still want to do this? You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take it off. And how do you plead to the offense, ma'am?
Yeah.
I'll find you guilty, send you to the agreement. Good luck to you. Thank you, Mr. Pons.
Ms. Ford for Raymond. POUR.
Okay.
What's, I'd like to challenge the PC.
Well, that's why I have you
I
here.
figured.
Because I thought it may be problematic as well.
Okay.
So let's talk.
So
You want to hear it again?
Yeah, I haven't heard.
Oh, you haven't heard?
Oh, okay.
Okay, please. Come on up, Ms. Paul. Okay, so it's a DWI, Class B. Mr. Pons, please.
Yes, Judge. On March 2nd, 2025, the officer was dispatched to an accident call on the 4500 block of Southwest Freeway. The defendant was passed out in the passenger seat of a tow truck, and the officer noticed that her eyes were low, her speech was slurred, her breath smelled like alcohol, and she had urinated on herself. The defendant stated she had one drink and was coming from a club. The defendant showed lethargic behavior, and the defendant confirmed that she was the driver and that no one was with her. Standard field sobriety tests were administered. HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant considered a breath, and the results were 0.128 and 0.118.
We have her in the passenger seat of a tow truck.
Right. So her statement alone isn't sufficient. That's all they have about her driving.
And Your Honor, in the complete OR, there's further statements that kind of clarify the time period that when this happened. The officer stated that at 7:20 a.m., that's when he was dispatched to the accident call, and he arrived at 7:21. And the defendant stated that she was on scene and she was coming from her residence from a bar called Good Mood that she had arrived at 3 a.m. And the defendant stated she had the one mixed drink only and left Good Mood Lounge at 5 a.m. when she proceeded to head home. And the officer found the vehicle on the right shoulder stalled with the front passenger tire blown out. So the traffic or the encounter with the defendant took place 2 hours according after when she left the bar.
But none of that same, well, go ahead.
Have,
Go down to you until you get.
so do we have an officer that actually sees her in the car in the ditch?
No, Your Honor, the car is just found in the
Oh,
ditch
she
with the
wants-
tire blown out, and the only thing the officers have to put her in the vehicle is her statement saying she drove and when she left the bar.
Well, that's it then. If that's the only thing they have, no PC.
Why?
Judge,
Their statement alone can't be sufficient evidence. They need corroboration.
and the corroboration we have is that when the officers arrived, there was nobody else on the scene. There was a crowded freeway. There was nobody else who could have gone to the accident or left the accident because they were on a highway with traffic and there were no other people around.
One, I don't see that the officer said any of that. Two, that's still not gonna corroborate that she was driving.
Why are you saying that the statement, her statement in and of itself is insufficient?
That's a rule. I can give you a case if you want.
Yeah, I do.
Okay, well, give
So,
me time.
Yeah, and I'm willing to, if you want, maybe like we can revisit on Monday,
Okay.
because I want to give you time. I want to,
Waive her appearance? For Monday?
yeah, I'm going to put her under conditions though, but yeah.
Understood.
Okay, but I'd like to do a deeper dive on the PC, and I want to know, is that in and of itself insufficient? And it'll give you more time as well.
I'll reach out to the officer.
Let's reach out Monday, and we'll do more, I guess, formal hearing. Ms. Poor, we will have an additional hearing on Monday to determine whether there's sufficient probable cause to go forward. So you need to stay in contact with Mr. Pons, and he will tell you how we went forward on Monday. As it stands now, I'm ordering you not to consume alcohol or illegal drugs while you're on bond in this case. Do you understand? If I find that you consume alcohol or illegal drugs, I'm going to revoke your bond. I will put you in jail. Could you guys run a license, please? And any other prior DWIs?
Your Honor, no prior DWIs, and we're running her license right now.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, you are not allowed to drive. Do you understand? Okay,
Your Honor.
great. So for now, I'm going to have you sign a reset with Ramona. We're going to set it for Monday. You don't have to be here. No. We're going to waive your appearance, but Mr. Pons will let you know how everything transpires on Monday. And then after you sign the reset, I'll have you meet with Fleischer for your bond conditions. And after that, you'll be free to go. Okay? Okay, Mr. Pons. Thanks.
Okay, thanks.
See you Monday.
So she needs to meet for bond conditions?
Yeah,
Okay.
she needs to sign the reset, but yeah.
Sign bond conditions from Fleischer, Judge.
I need her. I just need her.
SHIAK. And I'm also gonna approach on Herrera too.
Is that you in the waiting room?
Here's how Herrera look like. She's a spec. Oh.
Matt. Mariana.
Hello?
Mariana.
No, it's me, Judge.
Okay, are you ready?
I could wait.
No. Oh, I'm sorry, Matt.
Judge, I have two. One that needs a Spanish interpreter, but the first one, Shake, I don't think does. He's here on 3 cases.
Correct.
Conditions or anything that we need to address?
Yes, we've ordered him not to have any contact with the complaining witness, not to be, no weapons, not to go where she lives, where she works. There's a MOAC in place as well. I think that's the only thing that we
That's the
do,
only
right?
thing.
So we need him to sign the conditions, and after that, he's free to go with you.
And then the second one is Herrera, Rachel.
Is that the theft case?
Yes.
Okay, on that one, just no drugs, no alcohol, no going back to JCPenney.
Okay,
That's it.
all right, cool. Thank you. All right, cool.
Thanks.
Yes.
Okay, are you ready? Abel?
Yes, sir. Yes, sir.
Come up, Mr. Weber. Mr. Weber, you're charged with 2 cases. You're charged with assault of a family member. You're also charged with terroristic threat of a family or a household member. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Just so you know, I appointed you a lawyer yesterday. Your lawyer is here with you now. He is on Zoom. We're going to do probable cause now.
Yes, Judge.
Judge, I don't know if you remember, we did probable cause yesterday. You found probable cause, unless you want to revisit it.
I do, because I don't remember anything about it. And I want to be
Yes.
able to hear it with him so that we're all on the same page. Just real quick, if you don't mind.
No.
Okay.
Yes, Judge.
Thanks.
On March 4th, 2025, in Harris County, Texas, officers were dispatched to an assault in progress call. The officer met with the complainant and the defendant, who both stated that an assault did not occur. The officer then met with a witness who stated that he observed the defendant swing at the complainant 3 to 4 times. The officer spoke with a second witness who stated that the defendant opened the passenger door and punched the complainant 5 times. And when the complainant got out of the car, observed the defendant strike the first witness in the torso and shoulders. The officer then spoke with a third witness who stated that he saw the defendant strike the complainant 3 to 4 times with a closed fist and heard the defendant state he would fuck you up to the complainant.
Mr. Weber, I don't want you to have any contact with this person. Do you understand me?
In Your Honor, if I may, after having contact with the complainant and Sebastian for me as well, we would be okay with no threatening and harassing.
No.
Yes, Judge.
No. I don't want you to have any contact with this person. And I want you to understand now that I'm going to protect every person in my county, regardless of who they are, what color they are, they're a small farm animal. Do you understand? Don't have contact with this person. If I find that you violate these conditions, if I find that you become a danger to my city, if I find that you pick up a new case, I'm going to revoke these bonds and I will make them high. Do you understand?
Judge, if I may.
Please.
Judge, the CW was the one that came into court yesterday. She's a clerk for the Harris County district. She's a clerk there in Harris County.
Say it again?
She's a clerk there in Harris County.
The complaining witness is a clerk here in Harris County?
Yes, Judge.
Okay.
She's the one that gave us those affidavits yesterday that you showed me.
I understand, but I've got, go ahead. Go ahead.
She did not have any visible injuries. She states to me and to the district attorney that they were fighting over the keys and that it was just that it was mutual and that no injury occurred. She did not have any bruising again. She told that to the officer when she was arrested. Oh, I'm sorry, when my client was arrested. There were no visible injuries, nothing that would corroborate what the witnesses are saying.
There are 3 different independent, unrelated witnesses who see first 4 to 5 punches in the head, and then as he allegedly takes her out of the car, these same witnesses see 3 to 4 punches in the stomach as well.
Again, Judge, if that were the case, we'd have some injury, Judge. We don't have any injuries that are noted by the police in the report or by the CW when I saw her yesterday, or the prosecutor when he spoke to her yesterday, Judge.
Judge, just to confirm, yes, that's what the complaint told us as well. The same thing. There were no visible injuries, no bruising, and that's why I'm asking you, we'd be fine with no threatening harassment.
Come up, ma'am. I want to make sure that every single person here is protected, you know, and 99.9% of the time, I always like to follow what the complaining witness is, meaning you, what your wishes are. Because, you know, I really take that into account. I have to be honest that from what the witness's statements say, it sounds really, really just aggravating and just, I don't want you to say anything. And so when I see something of this nature, it really takes me back. And that's why, you know, there's a method to my madness and why I do what I do, and to, you know, to protect you, because I don't want something to happen to you. That's because you're the person I care about. What would you like?
After those affidavits, non-prosecution, for a reason, I never called the police. I don't know what they found.
I don't want to talk about the case. I just want to know do you want to have contact with this person?
Yes. We deal with a lot of things together. He didn't hurt me, so I want to.
There is an order for protection that is in place now. I don't give a rat's behind what is going on. I don't care what stressors you have in your life. But if I find that you put hands on anyone, I'm going to put my hands all over your bonds and I'm going to rip it. Do you understand? I don't care what is going on in your life. You put hands. It's really not going to go well. Number one. Number two, the court order that I have now, the order for protection, says that you're not to have any threatening or harassing contact with the complaining witness. I don't care what you think is threatening or harassing. It's what she perceives. So can conduct in and of itself violate this thing? If I go like this, is that threatening or harassing? It is, and it will land you in jail. Do you understand? I will do what you wish, but if I find anything happens in the future that hands are put, threats are made, I'm going to yank the bonds and that's it. Okay? So if you guys want to do a rip now, I don't know if you've already done it.
We've already done it.
Okay.
It's fun, Judge.
So do you mind filing no threatening, harassing, no weapons? You're not to be in possession of weapons as well. Do you understand? Okay. Take a seat for me while we get everything ready for you, sir.
Amendment up, Judge?
Yeah.
Judge, this right where we sit on Mr. Weber.
You want just a normal setting? Abel?
Yes, sir.
Here's Wade.
Yes.
5, 6 through the 8.
What'd you
May
say?
6 through the 8.
May 6th to the 8th.
How's the 8th?
Okay.
It's yours. Okay, Abel, thanks for coming back, man.
See you, Judge.
Appreciate you.
Yes, sir.
Ready?
This will be really easy.
I like easy.
Okay, Monday afternoon, about 3 o'clock, you owe me in the interest of justice on a Francis Ike.
Okay, I don't remember.
It's an old theft to be, but he's in the Fort Bend County Jail, and I guess they reached out when they notified, or when they found out they had the whole
Okay.
I just spoke to the chief across the hallway, since you're chiefless right now. She went ahead and took a look at his criminal history and all that stuff. They're filing a nollie for your signature, and I was told to report back by today on what's happening.
Sign it right now.
So as soon as it comes through, that's what's happening.
Do you want to wait for a copy?
Oh, I don't need it, but that's okay. But thank you, sir.
Easy money.
All right.
Thanks.
Earphone site? Earphone site?
Stare.
Is your face. You have any questions about them?
Anything else? Ramona, anything else? Who? What page?
It's an appointed attorney, but maybe no.
Herrera, Rachel.
Yes. Let me see if there's something. No, he's good.
Yes, sir.
Your Honor, may we approach real quick? This is one of our interns in bond forfeiture, and she was coming to see things today, so I just
Nice to
wanted to
meet
introduce
you.
you.
For coming?
Yeah.
So, what do you mean, just bond forfeiture?
She's in the bond forfeiture division of the DA's office, but
Okay.
she never sees real dockets, so she wanted to come down and kind of see how
Nice.
things would go.
They don't file the sire facias anymore, don't they? Don't, do they? Right?
Actually, we don't.
Or they like try to collect from people, basically.
Oh, no, not bond forfeiture. No, I don't think
I
so.
guess because we revoke instead of forfeit. I think that's why. Right.
And there's like a civil side as well.
It's because you're trying to get blood from a turnip anyways, right? Most people don't, have a lot of money, and then you try to get them for all the thousands of dollars and that, so that's why. But anyways, nice to meet you. Come, feel free to hang out anytime.
It's a good experience. Nice to see how it works.
Yeah, feel free to hang out more.
Thanks, Judge.
Did you guys file bond conditions on Bird?
Oh, okay.
So no driving, no weapons, please.
So now if you do research all weekend. Just a little bit of research. Okay. At least I won't be alone.
Yeah.
Actually, I'll let you know.
Yeah, there are videos.
Yeah, that's true. Okay.
Samuels?
Sage 13.
No, I put no conditions.
Minute?
Required to remedy all violations that random persons can be operated from building. No driving has to be found driver's license. Or the offense first of all. Monday and Friday, you're going to see Mexicans. I'm telling you, sure. That's sending them. This is your title. If you have any questions about this in the future, not seeing myself use another, they call the, anything like that.
Watch TV on yours.
Even if you're not getting all of the weapons, they have the senior. But I don't know if you want to do something about this signing. Finally, I have your next one, and that's the and we do need to pay that. We don't have to. So please make sure. And then have sign, figure out this paperwork, and then we will. Okay. There you go. Yeah, good. Court? Yeah. Right, this is it. I'm going to go through documents with you today. Everything that you're signing, you're going to sign those two documents. You're going to get a copy of the thing. First one is going to be your bond conditions, which I have others. So for the moment, you are currently on bond, so it's going to be the no drugs, no alcohol, appear in court when required to, no new law violations, random drug testing, which I'll go through in just a moment, and then don't drive unless you have valid liability insurance and a valid driver's license in your name.
Why do you want to go somewhere else?
Judge, the first one is page.
2501. Desert, hey, Jones was no PC by the magistrate. What say you guys? Same thing? Okay.
That's it, Judge. That's it.
Okay, I think we're done then.
Yeah, but I'm just gonna give Mr. Mallard a reset date.
Yep.
Bond conditions for Weber and Berger and United.
Say it again?
Bond conditions for Weber and Berger.
Got it. Give me a second.
Thank you, Judge.
Take care.
Thank you. Take care.
Yes, ma'am. All right, that's it.